Every Whoops, good morning, everyone. I just want to make sure that I'm on the right audio and microphone situation. Let me share my screen quickly. Here we are. Today, we are talking about what you need to know about the Landlord-Tenant Act. Thank you for being here. We appreciate it. We're also going to make this webinar a YouTube video afterwards, and we'll transcribe it so you can get all of the information at our website. My name is Matt Zalk with Keyrenter Property Management in Tulsa and Oklahoma City. Today we're talking about what you need to know about the Landlord-Tenant Act. The Landlord-Tenant Act is a state law that governs the rights and responsibilities of both tenants and landlords. And so we'll talk about that. Like all things in law, it's subject to somebody's interpretation at some place. So even if it says something here, as we'll discuss, a judge, if somebody violates a part of this, it has to be, one of the parties has to sue another party, and then it's subject to the interpretation of the judge as to whether somebody's violated the law. And so we'll go through a number of things here that are common practice. We'll also go through a number of things that I don't see happen very often, despite the fact that they are in this law. Let's get started. We're happy that you're here. I'm eager to share more about the Landlord-Tenant Act of Oklahoma. I think this is the 2018 version. I'll also, in the YouTube video and in anything that is part of the follow-up to this actual webinar, I'll share the link to where I find all the a copy of this Landlord-Tenant Act. Let me just think. I think this is the 2018 version. I had a copy that the sheriff gave me at some point, but I don't know where it is, probably in my car somewhere. I'd like to let you know that you can utilize the comment sections below this video to ask questions or offer feedback throughout the webinar. Again, my name is Matt Zalk, owner of Keyrenter Tulsa and Keyrenter Oklahoma City. Let us move on. Over the past few webinars, we've discussed the following topics. We've discussed benefits of using a property management company. Of course, doing all the, one part of that is doing all the bits and pieces that a self-managing owner might grow tired of doing: collecting rent, handling late fees, doing the monthly accounting, dealing with vendors, both sending vendors out and also paying them afterwards, and then accounting for all of that stuff on the back end, of course. We've discussed how to calculate rental return rates for your properties. That looks like, going into Google and finding a return rate calculator and actually putting in all the details, or using one that we've provided that we think is a fairly straightforward calculation of return on cash, return on your equity, return on the asset value, and when to know if a deal is worth pulling the trigger on. We've talked about best practices for screening tenants for your rental. All of that is, of course, doing the credit check that you may or may not have access to, but as a property management company, we do have access to, but then also talking to their employers, former employers, landlords, former landlords, credit score, checking criminal records, checking stuff as crazy as the terrorist watch list and the sexual predator list. I guess about as crazy as it should be, maybe. We've also discussed how to conduct an eviction from start to finish. That's a pretty lengthy process that involves affidavits and service of notice and a bunch of other stuff. Well, the only reason you would conduct an eviction is if somebody has violated the Landlord-Tenant Act, some portion of the Landlord-Tenant Act, including a contract that you've signed with a tenant, or if you're a tenant watching this, the contract that you sign with the landlord. That is certainly not impossible. We have some landlords that we have to educate on a fairly routine basis as to explain why they're in violation of the Landlord-Tenant Act and why they need to, for example, provide cool air or heat to a property that they don't want to provide that to, or why plumbing is a mandatory feature that has to be working in a property. So let's go on. Today we're talking about, again, understanding the Landlord-Tenant Act. Let's just dive right into it. There are a number of, there's a whole booklet, right? It's a small booklet, but you can get through it in an hour reading the whole thing, no problem. But there are a couple of terms, a couple of clauses in there that are really important, and I've drawn out a bunch of those. It's certainly not, the ones that I've drawn out are certainly not the entirety. They don't represent the entirety of that booklet of the Landlord-Tenant Act, but I've chosen ones that I think are frequently violated, frequently referenced in terms of our business, certainly as a property management company. In the management of 1,000 properties, we see quite a bit, and so I'm just going to highlight those for you. 41-110 says term of tenancy. Unless the rental agreement fixes a definite term in writing, the tenancy is week to week in the case of a roomer or boarder who pays weekly rent, and in all other cases, month to month. So what does this mean? If you don't have a lease, you're in a month-to-month lease with your tenant or your landlord. If you have a lease that expired, you are in a month-to-month lease. So you cannot just come to somebody with an expired lease and request that they move out tomorrow. It is not that they are in possession of your property illegally. They're actually in a tenancy, a form of tenancy agreement that is a month-to-month lease. Fairly clear. Let me move this out of the way so I can put this down here. Move this out of the way. So if you want to terminate that tenancy because somebody's in a 30-day lease, a month-to-month lease, let's leave aside for a moment the idea that somebody's boarding week to week, because we never do that. We don't collect week to week rent. We don't think that that tenant demographic is one that we want to spend our time with, generally speaking. Let's talk about how we get rid of somebody that's in violation of another clause, or somebody that you just want to get out because you want to do a remodel, or you want to move into the house, or you want to sell the house, or whatever it would be. 41-111 says termination of tenancy, except as otherwise provided in the Oklahoma Residential Landlord and Tenant Act. When the tenancy is month to month or tenancy at will, the landlord or tenant may terminate the tenancy provided the landlord or tenant gives a written notice to the other at least 30 days before the date upon which the termination is to become effective. The 30-day period to terminate shall begin to run from the date notice to terminate is served as provided in subsection E of this section. So we can get to that in a second. But in other words, a 30-day notice to non-renewal lease is required. What happens if you give somebody a 30-day notice to vacate? Let's consider a month that has 30 days. So if you give somebody notice in April, for example, which I believe has 30 days, and you give it to them on the 1st, that would be the as it says here, the 30-day period to terminate shall begin to run from the date notice to terminate is served. So that would be the 1st, would be considered the 1st day. And then on the 30th, that would be considered the 30th day. So on the 1st of the next month, theoretically, somebody is in violation of the notice that you have given. What happens if they are still in the property? Well, you have to begin evictions proceedings so that you get a judgment for possession of the property, which is hopefully not where a 30-day notice to non-renewal a lease or termination of tenancy ends up, but certainly could. It happened to us recently. We sold the property, but prior to selling the property, we gave a 30-day notice to vacate. And as of the 18th day of May, the person was still not out of the property. That ended 30 days, and they still weren't there. So eviction proceedings have begun. Termination of tenancy, this is 41-111. Unless earlier terminated under the provisions of the Oklahoma Residential Landlord and Tenant Act, or unless otherwise agreed upon, a tenancy for a definite term expires at the ending date thereof without notice. So imagine the scenario where your lease starts on January 1st. You should always question why a lease would ever start on January 1st, the middle of winter, which in Oklahoma is not a time when people move. But nonetheless, let's use it as an example. From January 1st to December 31st. At the end of that lease on December 31st, the tenancy has expired without any further notice. So you can, walk up and get possession of that property. In theory, the tenant would have moved out, and you would then use your key to go back in and change locks and do whatever's necessary to turn the unit. Do you think that will happen? Probably not, I would say. Just because the lease date states that it's ended does not mean that the person is ready to give you possession of the property. And if they're in that property on January 1st of the following year, you have now begun assuming they've paid you rent, you've now begun a month-to-month tenancy contract. So I would say it's probably best to say something to a tenant before the lease end date occurs. If you're a tenant, it's probably best to say something to your landlord before a lease end date occurs. On the first day of November or the first day of December, it's probably a good idea to reach out to your tenant and say, we have a lease that is expiring in 60 days or 30 days or whatever the case is. Do you want to renew that lease? Our leases, of course, state that renewal has to be done 60 days before the lease end date. And so we have a good idea of whether a resident of one of our properties wants to stay or not. It would be, I guess it would be foolish to expect that you go to a property on January 1st of the following year in the example that we're discussing, and that person has just moved out and you've never said anything to them, they've never said anything to you, but you know, walk in and do your lease term. So the written notice of termination is what this is about. 41-111 section E says the written notice required by the Oklahoma Residential Landlord and Tenant Act to terminate any tenancy shall be served on the tenant or landlord personally. So that means you have to hand it to them. So personally, unless otherwise specified by law. If the tenant cannot be located, service shall be made by delivering the notice to any family member of such tenant over the age of 12 years, residing with the tenant. If service cannot be made on the tenant personally or on such family member, notice shall be posted at a conspicuous place on the dwelling unit of the tenant. If the notice is posted, a copy of such notice shall be mailed to the tenant by certified mail or by mailing such notice through the firm mailing book for accountable mail as provided by the United States Post Office. So that's a separate thing. We don't use a firm mailing book, but there is something that that exists. And the point of this is that you have to be able to prove to the judge when you actually do when you're requesting judgment for possession of a property that you've served them via mail. The easiest way to do it is by certified mail, but there is a firm mailing book that allows you to send a bunch of mail and then have it stamped off at the post office, which gives you proof that it happened. So let's break this down. You either need to serve the notice, a written notice, on the person or somebody in their family over the age of 12. If you can't do that and you can't serve them personally, you've got to post it conspicuously. What does that mean? Staple it to a piece of wood on the trim, tape it to the front door, tape it to the back door. But it's really, that's something that's up to interpretation. What does a conspicuous place mean? What if you put it on the post office, on their little mailing box, right on their what do you call it? Yeah, your mailbox. What if that happens? If it's sitting on the front on a, anchored into concrete, and you post it there, is that conspicuous enough? What if you post it on the front door, but they use a garage access and always come through the back door? They'll never see the front door. They don't open the front door. What if you, and that's a real case, for example, we've gone to do evictions, locked people out of, or gone with the sheriff to lock somebody out. And the tenant says, well, I never received notice. And, they really didn't receive notice. And they thought that they were paying rent because the husband was, saying that they were paying rent or whatever happened. People are taken by surprise. They didn't receive notice. They didn't show up to court because they didn't receive that notice. And we thought, conspicuously placing it on the front door was an appropriate place, but they never received it because they just never opened their front door. They always go through the back. So subject to interpretation, but conspicuous for us means generally we post it on the front door if we have access, and the back door if we have access, and that hopefully gets through to the people that it needs to get through to. 41-111 section F says the provisions of this section shall not apply to an occupant who has no rental agreement with the landlord and with whom the landlord has not consented to create a tenancy. A landlord shall have the right to demand that such an occupant vacate the dwelling unit or the premises or both, and shall not be required to commence eviction proceedings. If the occupant wrongfully fails to comply within a reasonable time, the occupant shall, upon conviction, be guilty of a trespass and may be punished by a fine not to exceed $500. So, in other words, a squatter does not need to be evicted according to the law. However, in my experience, the police will rarely, if ever, enforce the removal of a squatter, and they generally need to be evicted anyhow. The police will say, well, we don't have evidence that this person does not have a lease. You cannot provide me with evidence that they don't have a lease. The absence of evidence is not evidence of absence, in other words. So the squatter may say, hey, I do have a lease, I've signed one, I can't present it at this moment, it was electronically signed or whatever. And the police therefore are reluctant, very reluctant, to remove people that we claim are, squatting. So they will require that you actually go to the courthouse and get a judgment for possession and service, and have that judgment served by the sheriff so that the sheriff can eventually get people out. The example, I guess the one time that I can think of the police showing up and removing people is when you have, for example, a signed lease contract with somebody else. So, we're moving somebody in on the 1st of June, for example, and we go in today and find people living there, in possession of the property that are not supposed to be, and you can prove to the police that there's actually a lease that's signed with somebody else, and those people are not, by way of identification or identifying themselves, are not the people that are in the lease, they will generally remove those people. They may or may not arrest them for trespassing, but they will remove them. So let me tell this person that I'm in a meeting. So the damage 41-115 is the damage or security deposits, or pertains to the damage or security deposits and where they're held. It says any damage or security deposit required by a landlord of a tenant must be kept in an escrow account for the tenant, which account shall be maintained in the state of Oklahoma with a federally insured financial institution. Misappropriation of a security deposit shall be unlawful and punishable by a term in a county jail not to exceed 6 months and by a fine in the amount not to exceed twice the amount misappropriated from the escrow account. This basically says you have to keep security deposits in an escrow account for the tenant. It has to be done in the state of Oklahoma. And if you don't do that, if you use that money, for your own well-being, if you use that money to pay for repairs on the house that are not related to that tenant's occupancy of the premises or whatever else, it's illegal, and you can actually, be put in jail. You can be fined twice the amount of the misappropriated amount. So there are a bunch of ways you could violate this. You could put this in in an account that's not FDIC insured. You can put this into an account that's not in the state of Oklahoma. You can not put this in your account. You can just put it directly into your operating account as a landlord, which would be your personal bank account. And if the Oklahoma Real Estate Commission were to question you or track that money, they would naturally find that you're in violation of this and may or may not fine you as a result. But it should theoretically stay in an escrow account. It is not your money as the landlord. It is the tenant's money that you are entrusted with holding. That's why it's in an escrow account, because you are in possession of somebody else's money. It's not yours. How does it actually become yours? Well, after a tenant moves out, there's an outstanding balance. If there are damages that exceed what would normally be considered normal wear and tear on the property, you would then be entitled to grant written or put in writing what those damages are and use that money to take the security deposit. So here we go, talking more about that. 41-115, damage or security deposits, Part B says, upon termination of the tenancy, any security deposit held by the landlord may be applied to the payment of accrued rent and the amount of damages which the landlord has suffered by reason of the tenant's non-compliance with this act and the rental agreement. All is itemized by the landlord in a written statement delivered by mail to be by return receipt requested and to be signed for by any person of statutory service age at such address or in person to the tenant if he can reasonably be found. If the landlord proposes to retain any portion of the security deposit for rent, damages, or other legally allowable charges under the provisions of this act or the rental agreement, the landlord shall return the balance of the security deposit without interest to the tenant within 45 days after the termination of tenancy, delivery of possession, and written demand by the tenant. If the tenant does not make such written demand of such deposit within 6 months after termination of the tenancy, the deposit reverts to the landlord in consideration of the costs and burden of maintaining the escrow account, and the interest of the tenant in that deposit terminates at that time. So what does that mean? The landlord can apply a security deposit towards losses caused by a breach of the Landlord-Tenant Act or specific rental agreement. So you can apply it towards rent that hasn't been paid, or towards various things that are, parts of the house that have been destroyed as a result of tenancy. You've got 6 months, the tenant has 6 months to request the deposit in writing. If that request arrives, the landlord has 45 days to return the money. If that does not arrive, the deposit reverts to the landlord, and any money that's been retained by the landlord has to be documented in writing, with the remainder of the money sent through, as it says here, the itemization has to be delivered by mail with return receipt requested if it's possible. If you don't have an address to send to, then you're not going to send a security deposit anyway. So there's very limited, if somebody hasn't given you a forwarding address or an onward address, very difficult for you to do anything. But if you do retain the portion of the money, it is because they have, they've delivered you possession of the property, written demand to do so. It has to be done within 45 days of the termination of tenancy. Cool. 41-121 of the Landlord-Tenant Act of Oklahoma says pertains to the landlord's breach of the rental agreement and the tenant's ability to deduct from rent repairs. And this is specifically related to supply of heat, water, or other essential services which affect the habitability of the dwelling. It says in Section A, except as otherwise provided, if there's a material noncompliance by the landlord with the terms of the rental agreement or noncompliance with any of the provisions of Section 18 of this act, which noncompliance materially affects health or safety, the tenant may deliver to the landlord a written notice specifying the acts and omissions constituting the breach, and the rental agreement will terminate upon a date not less than 30 days after the receipt of the notice if the breach is not remedied within 14 days. And thereafter, the rental agreement shall so terminate as provided in the notice unless the landlord adequately remedies the breach within the time specified. So this is similar to a 1015 notice, which says which a landlord would give to a tenant saying you are in violation of a clause of our contract. You have 10 days to remedy the violation or the non-compliance. Otherwise, your lease ends in 15 days. In a similar way, a tenant may send to a landlord a 30-day notice that highlights what portion of the lease is non-compliant, that is affecting materially, it's called, materially affects health or safety. And if it's not fixed in 14 days, the tenant may actually cancel their lease after the 30-day notice is over. This specifically refers to habitability of the dwelling and really relates to stuff that materially affects health or safety. That again is subject to interpretation to some degree. It's generally about heat in the winter, water, and other essential services. You cannot provide. The city will condemn a property that doesn't have a consistent source of water and sewage. And so if those services are not available at a house, whether because there's a main line is stopped up and sewage can't drain or whatever else, that has to be remedied by the landlord. And if not, the tenant can break their contract and leave. So again, the tenant can give a notice that if an issue of non-compliance isn't remedied within 14 days, the lease will terminate within 30 days. Very similar in essence in structure to the 1015 that a landlord issues to a tenant. So again, another portion, 41-121, that refers or pertains to landlord's breach of rental agreement, again, of the habitability of the dwelling unit, but instead of cancellation, we're talking about a tenant or resident of a property fixing the failure to provide an essential service themselves. This says, except as otherwise provided in this act, if there is a material noncompliance by the landlord with any of the terms of the rental agreement or any of the provisions of Section 18 of this act, which noncompliance materially affects health and the breach is remedied by repairs, the reasonable cost of which is less than $100, the tenant may notify the landlord in writing of his intention to correct the condition at the landlord's expense after the expiration of 14 days. If the landlord fails to comply within said 14 days, or as promptly as conditions require in the case of an emergency, the tenant may thereafter cause the work to be done in a workmanlike manner and, after submitting to the landlord an itemized statement, deduct from his rent the actual and reasonable cost or the fair and reasonable value of the work, not exceeding the amount specified in the subsection, in which event the rental agreement shall not terminate by reason of that breach. So, in other words, if a tenant has an issue that needs to be addressed and is the non-compliance of solving that problem materially affects health and the well-being of the tenant, they can pay $100 to have that work done. Now, I guess that's true. I've never seen it happen because $100 doesn't really do much. There's no way for anything that is really heat and other essential services. If you were to buy a mini split with not a mini split, but a window unit that had a heat strip in it, it would be more than $100. It would be unlikely that in very low income situations that a fix of a wall heater, which are now not up to code but exist, where they were grandfathered in, that fixing that would be $100. A plumbing situation where you had no plumbing because of a stoppage would be very hard to get a plumber to come out and snake a drain for $100. So I don't really know when this would apply. I think it's a bit archaic or anachronistic, relating to a time when $100 actually meant something, but in today's world, it does not. 41-121, landlord's breach of the rental agreement, again, related to the habitability of the dwelling unit, except as otherwise provided in this act, if contrary to the rental agreement of section 18 of this act, landlord willfully or negligently fails to supply heat, running water, hot water, electric, gas, or other service or other essential service, the tenant may give written notice to the landlord specifying the breach, and thereafter may, 1, upon written notice, immediately terminate the rental agreement, or 2, procure reasonable amounts of heat, hot water, running water, electric, gas, or other essential service during the period of the landlord's noncompliance and deduct their actual and reasonable costs from the rent. Or 3, recover damages based on the diminution of the fair rental value of a dwelling unit. Or 4, upon written notice, procure reasonable substitute housing during the period of the landlord's noncompliance, in which case the tenant is excused from paying rent for the period of the landlord's noncompliance. So the truth is, there's probably, in a situation where the habitability of a dwelling unit is thrown into question, it's probably not likely that a tenant would react in all of these ways, but they could easily terminate the rental agreement. They're going to, if they were to procure reasonable amounts of heat, et cetera, and then deduct their actual and reasonable costs from the rent, you know, you enter into an agreement, into a situation where you're probably better off just leaving, if at all possible, leaving and terminating the tenancy. So I don't see that happen very often. Recover damages based upon the diminution of the fair rental value of the dwelling unit. Again, you're just taking rent, you're removing that from rent, most likely, because that's your greatest tool. And, you know, I think the most likely situation is that somebody goes and gets a hotel and then requests that the landlord reimburse them for the cost of the hotel. Again, you know, it's a very touchy situation. I think oftentimes it's warranted, but if you are paying, call it $1,000 a month, that's $30 a day, about $33 a day, and going to get any hotel is, you know, in excess of $75 or $100 a day. So it becomes a touchy situation where landlords don't really want to pay $75 a day when the cost of their habitable, or in this case non-habitable, dwelling unit is really only 35. We have in some situations paid for it for tenants that have had, you know, I guess really dire situations where there's no heat in the house for some strange reason, and we have paid for people to be put up at hotels. I've only ever seen a tenant terminate tenancy once for lack of essential services being supplied. It's pretty unusual. When somebody moves all their stuff in, they rarely want to move unless they're absolutely required to. And we try to never let it get to that point where we would put in space heaters, we would put in everything. For example, in winter, prior to, you know, or to make a place habitable and not force a tenant into a situation where they, you know, are just absolutely miserable. So let's move on to 41-128. Let's talk about entering a dwelling unit. This is something that we see frequently. We need to get into do inspections of properties. We need to get into fix or abate, you know, maintenance issues that are prevalent. We need to do inspections for purposes of selling a property. For example, the owner wants to sell a property and the new buyer wants to do an inspection, and we have to facilitate that process. And so it's important that we are able to get in. We also, you know, see things that are a little more rare, but, you know, somebody goes on vacation and then a neighbor calls us and says, hey, there's, you know, there's somebody has broken in, or there's water flooding out of the house, or whatever. We've seen a lot of crazy things, and you know, we have the right to get in. So let me just read this. Section A says, a tenant shall not unreasonably withhold consent to the landlord, his agents, and employees to enter into the dwelling unit in order to inspect the premises, make necessary or agreed repairs, decorations, alterations, or improvements, supply necessary or agreed services, or exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workmen, or contractors. So this basically says a tenant can't stop you from coming in if you want to get in for a bunch of things that are bona fide reasons, right? Actual prospective or actual purchases, tenants. So if somebody has a lease that's coming up, you have the right to show the property to new tenants. You have the right to show the property to contractors that are going to do the make ready or repair things, etc. Section B says a landlord, his agents, and employees may enter the dwelling unit without consent of the tenant in case of emergency. So in things like like I highlighted earlier, flooding water or other emergencies, you can go in with a key and get into the unit to fix an issue. C, a landlord shall not abuse the right of access or use it to harass the tenant, except in case of emergency or unless it's impracticable. I wish I would say impractical, yes, but impracticable to do so. The landlord shall give the tenant at least 1 day's notice of his intent to enter and may enter only at reasonable times. Now, I think reasonable people have interpreted this 1 day's notice as 24 hours. You may make the argument that if I give a notice on Friday at 10 p.m., that Saturday morning at 8 a.m. is 1 day, right? Because it's Friday to Saturday. But reasonable people have said this is 24 hours, and I think that's the standard that we go by. So posting 24-hour notice to enter is generally required for routine entrance, but tenants should not refuse landlord entry. We were recently on an inspection, and a tenant wanted to refuse entry. We told them we could not refuse, they could not refuse entry, and that we were coming in to do an inspection with the buyer of a property. And the tenant came out and started coughing. The tenant's son came out and started coughing and making a huge scene, making it very unpleasant for the people that were doing the inspection and the walkthroughs to get in. Nonetheless, we were able to do it. It was quite unpleasant. We have plenty of anecdotes like that where we have had just terrible experiences with residents of our properties, but we have to sometimes explain to them what the Landlord-Tenant Act says. And so should you as an owner of a property. If you need to get in to do routine maintenance, if you need to indicate to them that they're in a month-to-month tenancy and they need to sign a longer term or whatever it is, you should know the Landlord-Tenant Act of Oklahoma. I will post the link to the in the YouTube video and in anything else that I put this webinar on, so that you have access to the full extent of the law language itself, and you can read it and interpret it for yourself. A disclaimer: I'm not an attorney. We work with attorneys to interpret the stuff often, but I'm not an attorney, and this advice should not be construed as legal advice, I should say, I guess. But it's important that you know what the Landlord-Tenant Act of Oklahoma says. Stay tuned for the next installment in our monthly webinar series. We're excited to be doing this, and we're excited that you're here watching with us. Leave comments, feedback, and anything else you'd like to in the notes section or in the YouTube video. Thanks so much, and we will see you next time.